Hi, my name is Michelle Holoubek, and I'm with the Washington, D.C. IP specialty firm Sterne, Kessler, Goldstein, and Fox. The Supreme Court has finally issued its decision in the long-awaited Bilski versus Kappos case. Although the underlying claim in this case was directed towards a method of conducting a business transaction, Justice Kennedy's first line of the opinion, I think, really sums up the case the best. This case turns on whether or not business methods can be considered patent-eligible subject matter. And as it turns out, they can. 5 justices joined the majority opinion indicating that business methods were considered patent-eligible. Justice Scalia provided the swing vote and joined in this section of the opinion. Another big issue in this particular case was the machine or transformation test. The Federal Circuit had promoted the machine or transformation test as the exclusive test for patent eligibility. Essentially, a method claim for the machine or transformation test had to be one of 2 things. First, it had to be tied to a particular machine or apparatus. Second, in the alternative, it had to be transformative in nature. If it didn't meet one of these 2 prongs of the test, then that method claim could not be considered patent eligible. The Supreme Court struck down this bright line rule and said that while the machine or transformation test is a useful tool in determining patent eligibility, it is not the exclusive test. We can assume that if a claim does meet the machine or transformation test, it would be considered patent eligible. But even if it doesn't meet the test, it may still be statutory. Unfortunately, the court doesn't give a whole lot of guidance on what else might be considered statutory. They remind us that there are 3 categories of subject matter that are never considered statutory: abstract ideas, laws of nature, and natural phenomena. And that's how they captured the Bilski claim. They indicated that this broadly claimed method of hedging risks and conducting business transactions was considered an abstract idea. But they didn't tell us exactly why it was considered an abstract idea. They didn't give us their reasoning, and they also didn't say what the metes and bounds of an abstract idea would be. So moving forward, practitioners in the Patent Office and the courts have little guidance on whether or not a claim, if it doesn't meet the machine or transformation test, would still be considered patent eligible. The court did leave room for the Federal Circuit to come back with new ways to limit patent eligibility. But of note is several types of claims that they said might still be considered patent eligible. This is software and diagnostic medical techniques. The Supreme Court said that these types of methods might be treated unfairly by the machine or transformation test. It remains to be seen how the Patent Office and the courts will treat eligibility from now on, whether or not they'll relegate it to the back burner or whether they'll continue to keep it in the forefront of patent examination. Regardless, the court's decision today gives patentees and applicants another bite at the apple of patent eligibility. Thank you.